This conference will now be recorded.
So welcome everybody who's joining me today on April 21st, 2021. Our topic today is the 3 most important documents that your 18-year-old must have before going to college or entering the military. So this time of year is very exciting. School is starting to wind down. If we have children that are in their senior year of high school or perhaps their senior year of college, their school is really done. They're probably looking forward to things like prom or senior graduation. And you probably are very busy starting to plan the graduation party. You might even be planning the family vacation that everybody's going to take before September. You're probably even getting your child ready to get off to college. You might be looking for bedding supplies and other things that they're going to need in their apartment or their dormitory. And if your child is not going to college right away, but perhaps has decided to serve our country and enter the military, you're probably going through a lot of the same steps to get them ready to go in for their training and possibly to be deployed. But the thing that we don't want everybody to forget before these wonderful, fun events happen is that your children need a legal plan before they go to college or go off to the military. So today, we're going to talk about what that legal plan means and why is it so important? Why can't we as parents still make medical and financial decisions for our children like we've been doing their entire life? You know, I'm a mother. I have a 13-year-old daughter. I have 2 older stepsons. One is 21, the other one is 35. And we tend to live each day in the mindset of, well, I decide what school my child goes to, I select the pediatrician, I make the medical decisions, I decide where they're going to live. And we think that way day after day, year after year, whether our children are healthy, even if our children might have certain special needs or developmental disability. And so we're kind of shocked and even shaken when somebody tells us that when our child turns 18, they're a legal adult and we can no longer make those medical and financial decisions for them. It kind of rocks our boat. And many of us might even be thinking, but wait a second, I'm still going to financially support my child. I'm paying for the dormitory or the apartment. I'm paying for the car insurance and other necessities. So what do you mean I can't make these decisions any longer? Well, the reality is that here in Florida, 18 is the age at which our children go from being a minor to becoming an adult. And that's really the basis for why we can't make the decisions anymore. So at 18, our children have all the same legal rights that we as parents have. They can vote, they can enlist in the military, they can even get married, and they no longer need your permission because they're an adult. They can make their own medical decision, which means we no longer are required to give written informed medical consent for a treatment, and they can make their own financial decisions. Now, I know that this may come as a surprise to many who are listening here today, but this is the demarcation where the law says we will no longer have access to any financial information and we will not have access to any of their medical information. So we can't just call up the college health center and ask, was my child there for a visit? You know, is my child sick? They're not going to speak with us unless they have permission from the student who's now an adult. So while we really want to focus on all the good, the positive, the fun things that are going to be coming up in the next few months, we can't stick our head in the sand and simply ignore that there may be unanticipated events that can occur that could cause our now adult child to become incapacitated. You know, the statistics that have been done, not just in Florida, but in all states, say that the highest rate of automobile accidents occurs between the ages of 18 and 25. Our children are new drivers. Sometimes they're distracted, especially with all the technology that is available today in the car, on cell phones. So accidents can happen that we would never expect or anticipate. But if that happens and it affects our child's ability to speak, to make medical decisions, we as parents are going to be in a very compromised situation that we wouldn't expect, which is we're going to be told we can't make those decisions for our child. And this was a situation that happened about 10 years ago. I received a telephone call one day from a set of parents who were very distraught because their son had been in a very bad car accident, and the doctors had decided to put their son into a medical coma to stabilize him. Now, during that period of time, because he was over 18 by a few months, they were not allowed to make medical decisions, and the hospital told the parents to go to court and be appointed the guardians, which is where I came in. I represented them, had them appointed guardian, but it was a very unsettling process. They were already very upset about their son's condition. He did come out of the medical coma, and it took several years of intensive therapy for him to walk again, talk, and do some of the basic everyday things we take for granted when we're healthy. Now, eventually, we were able to close the guardianship in the court, but that is an example of what can happen when we are not prepared and our 18-year-old or older young adult children don't have documents in place. If it's not an automobile accident, illnesses can happen. It's the one thing that I think we all have learned in this last year of COVID coming to the entire globe, that nobody is immune. It affects people of all ages, and even those people we thought were healthy and in good shape sometimes are affected the most. So we want to be prepared for the unexpected. Again, it's not unheard of that when our children go off to college, they're not living with us, they're in an unsupervised setting, all of a sudden they have a lot of freedoms and independence that they didn't have before. And with it, they also have the challenge of peer pressure. There are going to be parties where alcohol is being served, where there are drugs, and children are going to experiment. Sometimes they don't exercise good choices or good judgment, and they may experiment a little too much, and it's not unheard of for young adults to end up in the emergency room because of alcohol poisoning. So again, we don't want to be caught off guard. We want to be prepared and ready should any of these anticipated events occur. Now, while it's not a pleasant thing to talk about what's happening in our country with shootings, whether they occur in schools or other places, we do want to recognize that Hipaa, which is the medical privacy law in the United States, will not allow your children's treating doctors or even a hospital to release information to you unless they have your child's consent. And that is as a result of the Hipaa medical privacy law. So when the Virginia Tech shooting happened, approximately 3 years after Hipaa had become federal law, many parents who called the hospital where the news reported the children the college students were being taken to, were very shocked when the hospital operator refused to answer questions, refused to give any information about the child or the child's condition. And parents couldn't understand why they were being met with that kind of reception. And it was all because of Hipaa. Hipaa had become the law 3 years earlier. So without either guardianship papers or one of the documents we're about to discuss called a designation of healthcare surrogate, the hospital could not release any information. So we need to ask ourselves, if any of these unanticipated events occur, who's going to be able to make my child's medical and financial decisions? So the goal of today's webinar is that young adults, just like us, need a legal plan. So we're going to touch on 3 of the most important legal documents for them to have. And the first one is a durable power of attorney. Now, this document focuses on the financial side of our lives. It is a way of giving permission legally to someone we trust to make financial decisions for us if we're incapacitated. Now, incapacity could mean that we're physically unable to make financial decisions. Perhaps we can't go to the bank. Perhaps our ability to control our hands to write is affected. So let's think about some of the practical things we take for granted. We just do every day, every week, once a month. Maybe we're reading through our bank statement and reconciling it. Perhaps we're going to have a conference with a financial advisor. Or this time of year, we need to sign a federal income tax return. Well, what happens if we or our children can't do any of those things? Does it mean that they just don't get done? And the answer is, without that durable power of attorney, they're just going to be held up. Nothing is going to move forward. So it's important for them to have the durable power of attorney, even if you say, wait a second, they're going off to college. They don't really have assets yet that they've accumulated. Maybe they have minimal assets from working part-time after school. Or maybe they have some money that they received as gifts over the years from relatives. Well, let's think about what would happen if your child needed to temporarily withdraw from college because they were incapacitated and they had student loans. You're going to need to be able to communicate with the student loan companies. You're going to need to communicate with the college. So having the durable power of attorney is going to be very helpful to allow you to do that and have access to information and to be able to sign documents that are necessary. What if your child is not going to college right away and they're not going into the military? They've decided that they need to take some time off from their education to find their path. And so in the meantime, they're going to work. That's what happened when my older stepson finished high school. He wasn't ready to go to college. He wasn't sure what he wanted to do. So it took him about 3.5, almost 4 years before he went to college. And during that time, he worked in the food and hospitality industry. He made some very good money, saved a lot of it, bought himself a car, had an IRA. We might not expect that from a lot of young adults, but he did. So it was very important to my husband and I that he had a durable power of attorney naming his father and his mother and giving them the ability to make financial decisions for him should he have an accident, should he become incapacitated. So having that durable power of attorney was not just practical, but it saved us the possibility of having to go to court and do a guardianship if anything happened to him. So consider that, even though you might say, my son or my daughter doesn't have a lot of assets right now. Now we're going to shift and we're going to talk about medical advance directives. And these are important because this affects the other side of our life, which is healthcare, making day-to-day medical choices. So we're going to talk about two of the most important medical advance directives, although they're not the only ones. The first medical advance directive is the designation of healthcare surrogate. And to me, this is the most important out of all of them, because this is the way we actually legally say who we're giving permission to make our healthcare decisions. If something affects our ability to speak, to communicate, to understand the information that the doctor is giving us, to understand the choices for treatment, and we lack the ability to make an informed decision. So naming the surrogate, the person that's going to speak for us, going to stand in our shoes and make the decisions that are in our best interest, is of utmost importance. Now, we not only want to name one person, we want to think about naming an alternate. And there's no limit under the law as to how many alternate surrogates you can designate. The more is really better here. And here's why. No one has a crystal ball that we can look into to tell us whether the person we name first is going to be able to do the job when the time arises. There's no way to predict, are they going to be healthy? Will they perhaps have passed away unexpectedly? So if we want our management plan, this legal plan, to work, it is so important to name a primary surrogate and to name at least one, if not two, alternate surrogates. Now, sometimes people will ask, well, can I name two people to make the medical decisions together? And the answer is yes. You know your family and your friends the best. What you want to do is first speak with them, tell them what you're asking them to possibly do for you in the future, and make sure that they're willing to take on this responsibility. I think that it's best to have open communication and invite that other person to be honest with you and let you know whether or not they're willing to take on that role. It's better to have that conversation before the attorney prepares the document rather than your surrogate finding out afterward and then deciding they are not comfortable with being your medical decision maker. The next medical advance directive that is important for everyone of every age to have is what we call the Hipaa Authorization for Release of Confidential Information. So we've already talked about that Hipaa is the medical privacy law, and in order for somebody other than the patient to speak with the doctor or have access to test results, the physician or the medical provider has to have the consent of the patient. Well, if the patient is unconscious, if the patient can't communicate, it's going to be very difficult to get that consent. So this document is a way of giving consent in advance. Now, when you go to your doctor's appointment, you probably have had the experience when you check in with the receptionist of being given a piece of paper and being asked to sign it, saying that you've received that office's Hipaa policies. The reason that document may not work at any other medical location other than that doctor's office is if it has that doctor's name on it. So the Hipaa authorization I'm talking about doesn't have any doctor's name on it, doesn't have any hospital name on it, but it's just simply directed to any medical provider wherever you might be when you are receiving treatment or medical services. So by not identifying a particular doctor or a particular provider, it doesn't cause any limitations. It's actually more broader and should work for you wherever you go, whatever state, and whoever your healthcare provider might be. So in the Hipaa authorization, it says that you are giving permission to your healthcare surrogates to have access to information that might be considered confidential in order to allow them to make informed medical decisions for you. So these are the three most important documents to have. Now, there are some other medical advance directives you might want to consider for yourselves as well as for your children. One is called the living will, and the living will is a way of putting in writing a person's preferences for care when they are diagnosed with a terminal illness, meaning an illness that cannot be cured or cannot be reversed through current medical treatment and technology. If you would like to donate organs to either help another person or perhaps help advance medical research and study, one of the ways you can do that is to indicate it that you are a donor on your driver's license. However, if it's put in writing as what we call a declaration of organ donation, then you have the opportunity to be very specific about which organs you might want to donate, whether you want to donate them for transplantation purposes, or if the organs are not healthy enough, whether you'd like them to be used for medical research and study. In past years, one of the new technologies that has developed has to do with the application of skin grafting for people that have become burn victims. So you might want to consider that. You may also want to consider and put in the document what should happen with your physical body after the organs or other body parts are donated for transplantation or medical research and study. Another type of medical advance directive that can be very helpful, we call a declaration of funeral designee. Many people are not comfortable making funeral arrangements when they're still alive. Sometimes it's due to religious beliefs, superstitions. So it makes it a little bit more difficult when a person passes for family and friends to know, what did this person want? Are we making the right type of arrangements for them? So this document allows a person to designate someone they trust to make and carry out those decisions, and it also states whether the person prefers to be buried or prefers to be cremated. And you have the option of indicating any special requests, whether you would like a memorial service, whether you'd like there to be a celebration of life, or where, for example, what cemetery would you prefer to be buried in? So it can be very helpful for the people that you leave behind, so they're not guessing and they're making the right choices for you. So let's talk about when is a good time for you to have these documents prepared for your young adult children. Ideally, you want to be thinking about this now, before they leave for college or before they leave for the military. If there's not enough time to do that, then my suggestion would be get it scheduled for when they come home for their first break, which usually is around Thanksgiving. And if that's too short or they're not coming home, then plan it for winter break around December. So those are three opportunities for them to get these documents in place, and for not just you, but for them to have the peace of mind of knowing that it's been taken care of. And if you need the documents, they're going to be there. And it really will result in your family maintaining privacy because you're not going to court to do a guardianship. These documents do not get filed anywhere. They're not recorded in the public records. So you're maintaining privacy, confidentiality, and you're saving your family the expense that is associated with having to do a court-supervised guardianship. Now, for those of you who maybe have children of different ages, and while you have an 18-year-old who's going off to college or the military, you might have a child that's under age 18. And we don't want to forget about them because there's some very important planning that we as parents should consider. Florida is very unique in that we have a law that allows parents to designate a healthcare surrogate in writing for our minor children should we be temporarily unavailable. Perhaps we're traveling for work, or once it's safe because of COVID, we decide to travel for pleasure. Well, what happens when we're not there and our child becomes sick? Or perhaps our child has an accident. Does it automatically mean that the family member that we've entrusted our child to can automatically make medical decisions for them? And the answer is no, that is not automatic. So I like this idea of being able to designate a healthcare surrogate for a child that's under age 18. So if we or our spouse is not available, the doctor will look at this document and call the surrogate and inform them and give them the information needed to make an informed healthcare decision for our child until we can be reached or until we have returned. Another important document that should be part of our plan as parents is called the Declaration of Preemie Guardian for a Minor. And what this means is that should we unexpectedly as a parent become incapacitated or suddenly pass away, it allows us to name a guardian for our child. Now, this can be very helpful if, for example, we are single, if the other parent has already passed away or the other parent is incapacitated. We need to be thinking in a forward-minded way. So by naming somebody we trust, and you don't have to name the same person to make medical decisions as the person who will make financial decisions, you've ensured that the person you trust the most is most likely going to be the person that the court appoints as the guardian. So it creates a presumption. Now, who can be a guardian? Well, anybody who's either a Florida resident or related by blood or marriage could be a guardian for a minor age child. The only major exception to be aware of is if the person applying to be guardian has been convicted of a felony. In that situation, even if you chose that person in your document, the court will not appoint them. We have to be assured that the person to be appointed the guardian is a responsible person, is going to take good care of the child, and is going to properly watch over and manage any assets that the child might be inheriting. Now, this document, once it is signed, will be sent to the court and filed so that if it's brought to the court's attention that the parent is incapacitated or has passed away, then a hearing will be held and the person who's designated as the guardian will come to court to answer questions and to eventually be appointed the guardian. So this allows you to exercise some amount of control as to who your child will live with, who will make medical and school decisions, and who will watch over any assets that are going to be inherited. Now, What happens if we have a child who is now an adult, age 18, but they have special needs, or they might have been born with a developmental disability? What kind of planning can we do for them? Well, the answer to that question depends on each individual. There is no black and white rule that applies to everybody in every situation. We really need to meet with the parents and the adult child to see what is that child's comprehension level. What can they understand? Now, the ability to sign a designation of healthcare surrogate requires a lower level of understanding, or what we call comprehension, than what is required to sign a durable power of attorney. To sign a healthcare surrogate, we are going to ask the child questions about who would they like to make medical decisions if they get sick? Who do they trust the most? Very different than when it comes to financial decision making, where we have to see, does the child have a more comprehensive understanding, how aware they are to time, to place, to date? Can they tell us who is the President of the United States? Are they aware of assets that might be in their name? So we go through this process to determine, can we prepare documents for the child? Can we prepare the healthcare surrogate, but perhaps we might not be able to prepare the durable power of attorney? So then we're going to look at what other options do we have. And we have two very good options in the state of Florida. We have guardianship, but we also have something very unique called guardian advocate. And this is a type of a court proceeding that is meant to help families who have a child born with a developmental disability, such as autism, Down syndrome, cerebral palsy, spina bifida. The intent behind this law is to enable the adult child to participate as much as possible in issues that are going to affect them, to involve them in medical decisions, to involve them in financial decisions. But the law recognizes that when the child reaches a point where they can't exercise good judgment skills or reasoning skills, that's the appropriate time that parents or trusted family members should be able to legally step in and make those decisions. And we call the person who makes those decisions the guardian advocate, because they are advocating on behalf of the young adult who has the developmental disability. So for example, you might take your child for a dental checkup, and x-rays are taken as part of the process. And after the dentist reads the x-rays, the dentist determines that some form of treatment is necessary. Perhaps there is a cavity, or perhaps a root canal, or some other procedure is required. If the dentist is trying to explain this to your child and your child can't understand, can't really make an informed decision, then the doctor is going to ask, well, do you have a designation of healthcare surrogate signed by your child, or do you have guardianship or guardian advocate? Without one of those, the doctor is likely not going to perform the treatment until the dentist knows you have legal authority to authorize the dentist to proceed. The same would be the outcome if there was some sort of a medical surgery that your child required. So it's important, probably a few months before your child is going to turn 18, for you to start exploring these options and to meet with an elder law attorney that has experience about guardianship and guardian advocate. Now, the guardianship and the guardian advocate cannot be started prior to the day that your child turns 18. It's just premature. but you really want to start getting ready for the process about 2 months before your child is going to turn 18, so that if you have to file for guardian advocate or guardianship, the papers will be ready and signed and can be filed with the court the day after or the week that your child turns age 18. Now, many parents that I've worked with over the years prefer the guardian advocate procedure to a guardianship simply because they would prefer that their child retain all their legal rights. They want their child to have dignity and to have as much independence as they can possibly and safely handle. In a guardianship proceeding, the judge is actually removing certain legal rights, and for some parents, that is something that is not within their comfort zone. So you do have to decide what is best for your child, and that requires you to take a look at several things. For example, is your child very social? Or are you concerned that your child might be befriended by somebody who might not have the best motive? Could they possibly try to exploit financially your child? Is your child able to discern who's a stranger and who is somebody that can be trusted? So those are some of the things we explore in conversations with families and their children in order to determine whether guardianship or guardian advocate proceeding is best for that adult child. And so by involving the child and seeing how they answer questions, where they have their abilities and where they need the guidance of their parents or their family members, that will help to point us in the direction of deciding which procedure is best for your child. So I'd like to leave you with a couple of tips today and hope that this encourages you to take the next step. First, start to talk to your children as they're approaching their 18th birthday about why it's important for them to have the designation of healthcare surrogate, the Hipaa authorization, and the durable power of attorney. Help them to understand that legal planning isn't something that's just for older adults like their parents or their grandparents. Help them to understand that everybody at any age can unexpectedly get sick or have a car accident. And so it's important to be prepared so that mom and dad or a trusted older sibling will be there and legally be able to help make the medical and financial decisions for them so that we don't have to go to court. If you're listening to today's webinar and you're thinking, wow, I should have this for myself and I don't, this is a great time for you to start to talk with your family and friends and start to identify who would be a good healthcare surrogate for me, who would be a good agent under the durable power of attorney. Start to have the conversation, start to think about who would be the alternate, who's going to be part of your backup plan, your plan B. And then don't forget the importance of selecting a healthcare surrogate as well as a guardian for any of your children that are still minors under age 18. A child can be as young as a few months to a few years to be able to name a surrogate for them as well as name a guardian. And if you're doing this planning, it's also a good idea to address the issue of having a will or a trust as a way of passing on your assets. And if you have a beneficiary with special needs or a disability, it's a really good time to talk about having a special needs trust prepared so that the beneficiary, when they inherit your assets, will still be eligible for government benefits such as Medicaid and SSI benefits through the Social Security Administration. So it's a good time to start thinking about who would you like to leave in charge as a trustee to manage the Special Needs Trust, or even explore a professional trust company to handle managing the assets that are going to be inherited. Sometimes using a professional trustee can take off the stress and the pressure from family members that might need to serve as a guardian or a guardian advocate for the beneficiary with a disability. And last but not least, take your time to interview and find an experienced qualified elder law attorney. You can do this in a number of ways. You can contact your state bar association and find out who has specialized knowledge in the area of elder law. Many states like Florida provide a board certification process similar to what doctors go through to become board certified in a specialized area of medicine. So when you work with an attorney who's board certified, that means you're working with somebody who recognizes the importance of continuing their education, staying on top of changes in the law, so that you get the best advice and guidance possible. If you know of a loved one in another state who needs to find an elder law attorney, you can go to the website for www.naela.org. NAELA is spelled N-A-E-L-A. It is the National Academy of Elder Law Attorneys. They have a wonderful online directory, and you can find an elder law attorney in every geographic area of the country. And the directory will also tell you who is board certified. So I see we have a question posted in the chat box. It's saying if a minor is going to be 18 and has special needs, why go to a quote elder law attorney? This is a wonderful question, and I want to thank you for asking it. So when elder law became a profession about 35 years ago, many of us were in fact working with clients who were older. They were probably over 60 years of age. And that was the reason this profession was called elder law attorneys. But in reality, all of us begin to age from the minute we're born. And so we have to really shift our way of looking at the aging process and realize that these are things we all need to think about at any age, at any stage of our life, regardless of our marital status, regardless of our race, our nationality, our religion. Everybody is affected by the aging process. So by going to an elder law attorney, as opposed to just an estate planning attorney, you're going to get the best advice, because the way an elder law attorney is trained is to look at things holistically, to look at things with a 360-degree view, not a narrow myopic view of what is the client coming in for, but what does the client not know might affect the decisions they're about to make. So elder law attorneys are trained to ask questions like, do you have a beneficiary or a family member with a disability? Is that person receiving government benefits that we need to protect and save? Those questions are going to impact the advice you get and are going to impact the recommendations you receive. So you're going to receive a much more comprehensive, holistic approach toward your legal plan. Thank you for that question. I appreciate everybody who joined me here today. And I want to invite you to our series that's going to start in the first week of May. May is traditionally known as National Elder Law Month. And so each week we're going to be hosting a webinar on a different topic for, as I said before, all different ages. May 5th is our first topic, and it's called Lessons from the Front Line. It's going to be a panel of elder care experts talking about their experience of either being a caregiver or having a loved one that has had an illness or an injury, and what did they learn by going through the process that everybody needs to be aware of before they're actually in that situation. So I invite you to go to my website, www.fl-elderlaw.com, and if you go to the events page, you'll see the calendar with all the May elder law webinars that will be coming up, and you can register very easily to receive the links. I see we have another question that's been posted in the chat box, and the question is, for a durable power of attorney, should this be notarized? And the answer is, in Florida, it must be notarized. If it is not notarized, it is not a valid document. So every state has requirements for how a document needs to be properly signed. For example, in Florida, a durable power of attorney must be signed in the presence of 2 adult witnesses over the age of 18. Preferably, we don't want those witnesses to be related to you. It's better to use the attorney's employees. And the document must be notarized. So everybody has to be present in the same location at the same time that the document is being signed. If it's not considered a valid document, and it's not going to be effective. So do be careful. I know that there are things on the internet like LegalZoom. You've got to be very careful if you want to be an informed consumer these days, because that website or that document is not going to speak to you. It's not going to have a conversation to understand what's happening in your life, in your family. It's not going to ask you what your concerns and your goals are to know if you're completing the document correctly and if it's going to do what you need it to do when the time arises. So at this time, I'd like to open it up to any other questions anybody would like to ask. You're welcome to either unmute your microphone or write your question in the chat box. So I see there's no other questions. I'd like to thank everybody for joining me today for this webinar. Continue to be safe and healthy. Have a great rest of your week, and I look forward to seeing you in May.